Welcome to our special coverage of the Noor Salman trial here on clickorlando.com. I'm Kirsten O'Connor. The defense has rested its case in the federal trial of Noor Salman, the widow to the Pulse nightclub gunman. This morning, they called a major witness to the stand, a forensic clinical psychologist who specializes in false confessions. News 6's Nadine Yanis joins us now live from the federal courthouse in Orlando. So Nadine, his testimony is a big part of the defense's case.
Kirsten, this is probably the biggest move from the defense to contradict what is the biggest piece of evidence that the prosecution says they have against Noor Salman. This 12-page written statement that with this expert who took the stand today, the defense says is a false confession.
False confession testimony occurs all the time, but it's for the jury to decide.
Forensic psychologist Dr. Bruce Frumpkin sat down with Noor Salman for 11 hours to evaluate how susceptible she may be into giving a false confession. The Miami-based doctor specializes in just that, and this morning told the jury Salman has a number of mental illness and intellectual disabilities, including anxiety, OCD, and a lower than average IQ of 84. Adding that, under the circumstances of Noor Salman's 11-hour interrogation by the FBI the day of the attack and sleep deprivation, that she, quote, is very vulnerable and at a much higher risk than the average person in giving a false confession. Especially, he said, if the FBI used the common police practice called the Reid method, a 9-step process, he testified, in which law enforcement uses to get confessions that are psychologically coercive but legally permissible. And the 9th step, he said, is usually when the statement gets written down. Most of the time, Dr. Frumpkin testifying, the officer will write it themselves to be in more control of the admissions of guilt. This testimony directly pokes holes in what's the prosecution's biggest piece of evidence against Salman. What they say is her 12-page written confession from the beginning, her attorneys and family say, is 100% false.
I'm just waiting for that moment to finish the trial and show that she's innocent, so I can tell everybody, I told you so, she's innocent.
And so with Dr. Frumpkin's testimony, the defense has rested their case. We were wondering if Noor Salman herself was going to take the stand. This was a decision the defense says that they were going to make last minute, and it looks like they have decided against it. So with that, they are going over jury instructions, finalizing that as we speak. Closing arguments are scheduled for tomorrow morning. And Kirsten, that means by tomorrow afternoon, the jury could have Noor Salman's fate in their hands.
Nadine, I know that was a highly anticipated moment to see if Noor Salman would take the stand. You said that she didn't. Was there any reaction from her on this final day?
No, the only thing I saw was at one point a break. She turned around and she looked at her family and just went, like, that's it. I guess we'll see what happens next. And she always makes that eye contact or a smile or something with her family before she leaves. She does seem tired. The family seems tired. This has been somewhat of a marathon being here every day, and it's going to be wrapping up here pretty soon with closing statements tomorrow.
Nadine Yanis reporting live for us outside of the federal courthouse in Orlando. Thank you, Nadine. And joining us now is News 6 legal analyst Jason Johnson with Lowndes Law Firm. Jason, thank you for being here with us all day. So we just heard from Nadine about this final day. The defense rested its case. What are your thoughts?
Well, it's about as I expected. I did not expect Ms. Salman to take the stand. We anticipated yesterday afternoon when we heard the judge's ruling on the motion to dismiss her for a mistrial that we expected only this witness, this expert witness this morning, and that would only take about a half day. So given the court's comments yesterday, I did not expect Ms. Salman to take the stand. Everybody wants to see that happen. The public certainly wants to hear what she has to say, but a criminal defendant taking the stand in their own defense is fraught with risk. It certainly gives them a chance to tell their story, but it also gives the government a chance to cross-examine her and to potentially elicit some pretty damning evidence from her, especially when they have this written statement that the defense likes to plaze up is not in her handwriting, but they conveniently leave out the fact that each and every paragraph has her initials, both at the beginning and end of the paragraph, and each of the 3 separate written statements has handwriting at the end of it of hers, kind of explaining what happened and why. So it's not as easy, or it's not as clear-cut as the defense likes to say that, you know, this isn't her written statement, especially when you have evidence, forensic evidence in the form of video, purchase receipts showing that she did a lot of what she actually says she did in the written statements. So while the defense is going to point to this one provision in the written statement that says, I cased the Pulse nightclub with Mateen during our second trip to Orlando, or during our first trip to Orlando, and the forensic evidence doesn't support that, the defense is going to point to that and say, that's not true. If that's not true, you can't believe the rest of it. The government is going to say, while that may not be true, the rest of what she said is backed up by the forensic evidence, and here it is.
Right.
They're going to put everything on a silver platter in their closing statement tomorrow, tie everything up with a nice, neat little bow, and hand it off to the jury and say, here is the evidence that proves beyond a reasonable doubt that Noor Salman aided and abetted her husband and obstructed justice by lying to the FBI.
And that's the question I think a lot of us have, is what are we going to see in these closing arguments? We talked a little bit about this earlier, but it's not going to be like you see on TV.
Right.
These are going to be long, thought out, point-by-point arguments that, could take quite a bit of time tomorrow.
Yeah, it's not nearly as entertaining as we see on Law and Order or things like that. The closing statements are going to take longer than 30 seconds. Everything's abbreviated, of course, in television shows, but the government expects to take about 3 hours with its closing statement, and the defense expects to take about 90 minutes. So I anticipate that shortly after the lunch hour tomorrow, the judge will be charging this jury, and they will get this case for deliberations as soon as tomorrow afternoon.
Okay, so part of what that is tomorrow is the jury taking some time privately. We won't know how long the jury is talking to each other until, it could be days.
Correct. I mean, everybody wants to know, how long will it be before we have a verdict? And the answer is, you just simply can't tell. And you don't know how the jury is going to act once they get in the privacy of that deliberation room. Remember, they haven't had an opportunity to speak with each other about this case throughout the trial. They've been instructed from the beginning that you cannot view any media, you can't talk to each other, can't talk to your family, but you can't talk to each other, which I think surprises most people. They think when you get on a jury and you're hearing the evidence during the lunch break, you're kind of chatting about what you heard. They can't do any of that. So they've had all these thoughts and feelings bottled up in their head. And so this will be their first chance to speak with each other once they get in the deliberation room. You don't know if the foreperson, once they're selected, is going to simply say, okay, who thinks she did it? Raise your hands. And if everybody says yes, then we walk out with a verdict. It shouldn't be that simple. It should be a deliberative process where they go through the evidence and they go through the judges charging the jury instructions to them and say, here's what you have to do. You need to go down line by line each of these items in the charging form, the verdict form, and you need to decide whether the government proved each of these beyond a reasonable doubt. It should be a deliberative process. I hope it's a deliberative process. Justice demands that it be a deliberative process, but you never know how a jury is going to act once they get in that deliberation room.
I think another point that people will bring up who've been following this trial closely is that the abuse was never brought up on either side of this argument. We heard for months that Noor Salman had simple kind of characteristics, but also that she was an abused wife and that Omar Mateen may have coerced her in some way, but we never heard that.
Yeah, there was a lot made, excuse me, heading up to the trial that she was an abused spouse. There were statements made in some of the pleadings filed with the court that Omar was abusive with her, but we didn't have any evidence admitted into court that shows that she was abused. And I think that's probably because the defense didn't believe that it was necessary to aid in their defense. The information that they elicited from their witnesses yesterday tended to be along the lines of, she's a nice person, so her personality doesn't jibe with what the court thinks she did. Also, there were a lot of references to her yesterday being somewhat childlike. And that ties in with the defense's expert witness today about his testimony on the Reid technique. And that's an interrogation technique that begins after this initial process of gathering information. And once you determine that your interviewee committed the crime, then you begin the actual Reid interrogation technique, which is this 9-step process. And it's a manner of first telling them, here's why we think you did it. We have all this evidence. And it goes through these different steps of trying to get them to refrain from stating I didn't do it as often, deflecting to other people, using some coercive techniques, or at least critics will say they're coercive techniques that will, for instance, to say, well, did you do it in the heat of the moment, or was this something planned? And either way you answer that question, you're admitting guilt. Of course, there's the third option that, well, I didn't do it. But sometimes people, at least the critics will say, after a lengthy interrogation, if you're sleep deprived and if you have a diminished mental capacity, will have a tendency to answer that question one way or the other, which then admits guilt, and now you've got a confession. Mm-hmm. So there are a lot of critics of this Reid technique. Interesting story is that the FBI's manual was accidentally put into the Library of Congress, and it essentially showed that the FBI does routinely use the Reid technique. Mm-hmm. There's been some question about whether they actually do that, but I think it's common knowledge now that they do use this interrogation process. So there's a lot of criticism of it, and the defense used that today to try to argue that her confession was forced and likely false. And it also pointed to the fact that a lot of times you get false confessions from children using this technique. Right. She's considered childlike. Right. That's, I think, why that was the purpose of that testimony yesterday, was to try to tie it in with this false confession theory. And notably, this expert witness did not say, he did not testify that this confession is false. He simply said, given the factors at play here, the length of the interrogation, how long she had been without sleep. Remember, they woke her up at 3 a.m. in the morning. There was also evidence that she had been texting as late as 2 a.m., so she was without a lot of sleep before she went to bed, and then she was up for an extended period of time. She was very sleep deprived. She has a lower than average IQ. All of those factors play into her having a higher propensity to give a false confession using this Reid technique. And so the defense will point to that and say, you can't trust this written statement. And here, this is evidence that you can't trust it by the virtue of the fact that it contains a claim that she cased pulse. So with that and with this testimony from the false confession expert, you can't believe any of it, or at least there's reasonable doubt about your ability to believe it. And if that's the case, you're required to acquit her. But either way, it goes back to that testimony. It goes back to that written statement. That is what we're hinging on. Well, I think that's very likely what the jury will use as the linchpin for its decision. Certainly the government believes it has a lot of other evidence, including the evidence of their elaborate spending prior to the attack taking place. They spent more than a year's worth of his salary in the weeks leading up to it. That they have evidence that she participated in that, and those acts in and of themselves were aiding and abetting, that she certainly admits to it in the written statement. But even if you were to discount that written statement completely, you still have plenty of evidence to find her guilty of aiding and abetting. My gut reaction is that it's largely going to depend on how the jury views that written statement. If they believe any of it, and they don't have to believe the part about her casing pulse, they can discard that and say, hey, look, but we'll believe the rest of it. I think if they believe any of it, then the government has her dead to rights on both aiding and abetting and obstruction of justice. Yeah. All right. Well, we will see tomorrow what we find out. It's always a surprise. Every day of this trial has been a surprise. We could have a verdict by the end of the week, but I wouldn't be surprised if it goes into early or middle next week. All right. Wonderful. Our News 6 legal analyst, Jason Johnson with the Lowndes Law Firm with us. And because this is a federal trial, no cameras or recording devices are permitted inside of the courtroom. So News 6 and ClickOrlando.com have reporters at the trial every day. We also have this special page on Twitter detailing everything that happens. And then it also shows up right on ClickOrlando.com. Just look for the Noor Salman tab. Join us tonight at 6:30 for another discussion with News 6 anchor Matt Austin, investigator Mike DeForest, and legal analyst Mark O'Meara. You can watch that live right here on ClickOrlando.com. Thanks again for joining us this afternoon. I'm Kirsten O'Connor.